Introduction to Turquand's rules, often known as the Indo Management Rule, was established to make a commercial dealings easier by allowing a person dealing with a firm in a good faith to make a certain assumption regarding the company's internal operations. The assumptions. Firstly, the person contracting was a party to the inner produce may lead to the knowledge of an irregularity, where a transfer of share was allowed by the two directors, one of whom was disqualified because he was transferred himself, and the other was never properly nominated. Secondly, the Turquand rules may be disregarded in the same cases due to the forgery. The plaintiff was the transferor of a share certificate issued under the defendant company sale. The certificate was issued by the company secretary, who has affixed the company's sale and faked the signature of the two directors. Thirdly, the assumption addresses the most contentious and perplexing component of the Turquand rules. The term power of the delegations is commonly seen in articles of incorporations. Fourthly, when the circumstances surrounding the contract are questionable and thereby demand investigations, the Turquand rules provide no protections. Suspicions should be aroused. For example, if an officer is professing to act in a matter that appears to be outside of his authority. Lastly, if an act of an officer of a company would generally be outside the power of such an official, the plaintiff cannot invoke the Turquand rules because the act could have been delegated to him under the articles. The plaintiff cannot sue the corporation unless the power to do so has been transferred to the person with whom he deals.
The case based of Royal British Bank vs. Turquand. The case of Royal British Bank vs. Turquand 1843-60, all a representative 435, where the defendant intended to evade the liability of a £2,000 bonds by pleading that there had been no resolution authorizing the making of the bond by two directors. In this case, the directors of the company were authorized by the articles to borrow on bonds such sums of money as should from time to time by a special resolution of the company in a general meeting be authorized to be borrowed. A bond under the seal of the company, signed by two directors, and the secretary was given by the directors to the plaintiff to secure the drawings on the current account without the authority of any such resolution. Then, Turquand sought to bind the company on the basis of that bond. Thus, the question arose whether the company was liable on that bond. For the court judgment, the Court of Exchequer Chamber overruled all objection and held that the bond was binding on the company as Turquand was entitled to assume that the resolution of the company in the general meeting had been passed. So that's all from our group. Thank you.